Hey all, good morning, afternoon, or evening, whatever it may be for wherever you are. I am Stephanie Joy with all things Social Security and the Joy Disability Law Office. Your video is about to start. I wanted to remind you of our live Q&A sessions here on YouTube as well. They start at 1 p.m. Eastern Standard Time, so it's a little earlier for you Western folks. And I look forward to seeing you there. It's a first come, first served basis in terms of the questions you might want to pose in the chat. And I will pick them up going from beginning to end for about a 2-hour period. So anyway, I hope to see you there. Have a great one, and I will talk to you guys later. Bye. Dio, nice to see you. My mental health counselor used the word innocuous in describing my paranoia. I'm concerned about that. Should I be? Well, I think it means you're not dangerous, right? Dangerously paranoid. I mean, there's paranoias that are very dangerous, right? And you're not. You're paranoid, but you don't, it's not in a way that would hurt anybody. I think if it was other than that, you would have a serious problem and your freedom might be curtailed. So I think that's okay. Paranoia in the workplace is really interfering with work, generally speaking. I mean, people don't often deal with their coworkers very well. They don't necessarily deal with their supervisor very well. Depends where their paranoia, goes out, their intolerances. But I don't think the word innocuous is something to be concerned about, because if it wasn't innocuous, then I think you have bigger concerns outside of winning a claim. So I don't think that's bad. It'd be nice if there's evidence of examples of the paranoia. I don't know if you did a function report, or if a third party that you trust is the one that talks about he acts paranoid a lot, doesn't trust anybody. Ways that it would be interfering, examples of the paranoia and how they interfere with something. Maybe you won't go into a store in person because you're paranoid of being close to people, strangers, but you will order online. And maybe the ordering online for food is because you're paranoid to go in, not because you physically can't. But don't worry about the innocuous. I think most paranoid people are innocuous. They're not dangerous to everybody. So you just saw a little clip from one of our live Q&As. It might leave you more questions, particularly if you had a little piece of that applied to you and some more facts that would make things different. If you do, feel free to put a comment down below about the extra details, and we could maybe even make a video on the particular aspects of that you'd be interested in. So in any event, I hope to see you on Wednesdays, 1:00 p.m. Eastern Standard Time. And also 9:00 a.m. every day, we have a share from the field, so to speak, of things that happen in our workday. So hope to see you then, and I will talk to you later. Bye-bye. Just a little share about a communication I received from a coworker of a client. It's a former coworker. Obviously, the client's no longer working, but it just drives home that you can get evidence, even though medical evidence is the foundation of all of our claims. The non-medical evidence can be very helpful. It can really help paint the picture, particularly for a case that might be, like so many of them, near the middle line, on the fence, and you know that it could go either way with an adjudicator or an ALJ. And I would say my thought is that coworker or supervisor statements are really going to be most effective at an ALJ hearing, or submitted to the ALJ before the hearing, of course. And I say that because it's not clear to me that adjudicators are able to use it, since it's not medical evidence. And I'm not sure that the medical expert in the SSA, who's the one that then kind of categorizes your RFC, whether they take note of these things. So I say that loosely, not really well researched on it. I don't know if there is any research on that, but that is my impression. But ALJs certainly see everything, and they use their discretion, and they use their common sense and their brains in a way more comprehensive than at the lower levels, which some of us have the perception that it's more like a checkbox type of thing. You either meet the check boxes or you don't. And fortunately, that's why so many get overturned at an ALJ after an ALJ hearing or once an ALJ gets to look at everything. But in this case, it was upon request. It was someone that we knew from our client that this coworker, they got along fine. He'd probably be willing to communicate his recollections on some of these behaviors and symptoms. This is a mental health type of piece of evidence. And in this case, it concerned the frequency in which the client, who was the coworker, right, would have to leave the work area to go regain composure. Like maybe the onset of anxiety attack or panic attack in the workplace. And so there would be a lot of what might be seen as an excessive amount of break time to go regain composure in the bathroom or walk outside the building a few times, go around the building to recollect, recompose oneself. It could be, I know in this case, it could be with discussions with customers that, I have a feeling it was when a customer was complaining about something, this person had a very hard time coping and properly responding to a complaining customer. It's with ease for many of us, and then for some people, that brings on such great anxiety for whatever reason. That's just a symptom of maybe what's a disorder, like an anxiety disorder. So the description by the coworker, the former coworker, is really helpful because he does explain that it was frequent, like multiple times a week, when something that is part of that job, kind of having to deal with customers here and there, and some of them are going to be, not happy customers, and the low threshold of tolerance, the claimant, the one that's disabled, in our opinion, the threshold of tolerance was not very high for this person, so he couldn't withstand the very normal customer complaint situation in this kind of job. And there would be a lot of excess breaks. There was not as frequently as the breaks, but at times if things got out of hand too quickly, there could be breakdowns and tears and then going home altogether. Those weren't that common, but they happened, and this coworker was willing to put it on paper. What I do sometimes is I speak to a witness like that and have a conversation and hear what they have to say, then ask relevant questions that they may not have thought of to tell me about because they didn't know, if it would be relevant, and it might, the question from me to them might trigger something else. So we have a little back and forth, and then I, if they need me to document what they just told me and send it to them for their editing or review, that's perfectly fine. And it will be submitted probably attached to an SSA 795 form, which is where a witness or anybody else can make a certified statement. You're kind of under oath. It's certified, and you are subject to problems if it's found out that you are willfully lying. So it's a good little form to have when someone wants to speak what they know. It kind of puts the onus on them to be honest. And that will be something that will be submitted. It's not always possible to get them. A lot of times we don't maintain relationships, particularly if a lot of years have gone by. I've gotten these forms for physical problems too. I think I had a video where I discussed one of them, and it was a person with very bad, probably vascular problems in their legs and their feet, a lot of swelling, a lot of pain, and a really industrious person who ran around, worked like a dog running around, but then on every break time would be up in the employee break room having to put those legs up because those feet were just humming and the legs were swollen. And that was one that we did prevail on. And the coworker, which was this individual was, much older than the coworker, The coworker that was giving the statement was very generous, a very young person who just, wanted to do the right thing and knew exactly what he saw and witnessed and observed months on the jobs prior to the person actually leaving their job. And that was I think, a really helpful piece. If you can get one from a supervisor, that's great. Sometimes, again, some people have a fear or a paranoia that they are going to be putting their company in jeopardy of a discrimination claim. No, 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 and no. Uh, Two different animals and not related. So when people can give a statement of what they saw, if it's helpful, it's a really good thing to get. So if that is something that you have, now that you think about it, you might have that possibility. If you have a representative, I think you should tell them, and you could beforehand perhaps reach out to the coworker and say, if I could use a statement about what you did, witness this with me and like what I was going through, what did you see? Would you be willing to just write a little note about it? By all means, if you have a representative, maybe let the representative talk to them, get their permission that they'd be willing to speak to your representative, who can call them and find out what they know and how we can get this on paper. And it can really maybe make it's like a piece of objectivity that is not medical. And when I say objectivity, it's objective in the sense that it's not your friend, your family member, someone who has a conflict, wants to see you win and get your cash benefits. It's not that a coworker might not want that for you because they think you're disabled, but they don't have that same bias or loyalty, familial, diehard loyalty that many family members would have. So it has a little bit more objectivity than if it came from a family member who, of course, is going to say all that stuff, which is why 3380s are not the most, I'm just looking at a big bird out there flying overhead, is not the most helpful of documents. Probably it could be more hurtful than helpful, actually, but those outside, more objective statements from non-family members and people that are not just my friend, like a coworker, is a little more objective. So anyway, give it some thought. Most of us, particularly if we haven't left that long ago, and if we haven't burned every bridge we had at our last job, we maintained an acquaintanceship with somebody, it might be something you can get. You never know. Which also reminds me to add that if you had performance reviews that were not so good prior to maybe being terminated, or you quit before you were terminated, get your hands on those performance reviews. Or if you had write-ups, about whatever problem, maybe it's behavioral, maybe it's not keeping up the pace, where they're, giving you little warnings that your performance is not up to par. If that performance failure is due to impairments that you're claiming in your claim, then those could be helpful. I know nobody likes to acknowledge that they got a performance review that was non-stellar, but I love them when I see them for my clients because it helps show that, see, they really couldn't do this job satisfactorily. And remember, at step 4, we have to prove whether we can do that prior job. And that was proof of why they couldn't. And not only would it be proof of why they couldn't do that job, it will then go on to help prove at least some jobs, perhaps, that they can't do in step 5. All right. Chat with you later. Bye, guys.